There is a lot that is going on since yesterday and the day before yesterday that needed clarification. Hence, the reason why we called you, so that we can be able to inform the members of public and our members on the situation. I'm sure you are aware about the wrenching controversy about the music used by the Raila Odinga presidential campaign and Azimio, the video that included some extraction or adaptation of Sauti Sol music. And Sauti Sol, our members, MCSK represents about 15,000 members, including Sauti Sol. We represent these members these members, the 15 of them, including Sauti Sol, 15,000 of them, have assigned or signed deeds of assignment transferring their rights as artists to MCSK so that we can administer the copyright on their behalf. This is a job we have done for decades, since we were established in 1983, and we have done with great competence, and we have not had a problem in representation of our members. However, as you know, technology is evolving, and as technology evolves, a lot of contradictions or new dynamics about how we relate and how we operate do come in. Our position has been that the rights assigned to us by our members cover both performing rights and mechanical rights, which include synchronization. The issue Sauti Sol is raising is about synchronization, which in their view can only be given, the authority can only be obtained from the author or the publisher themselves. For us, we are responding or clarifying that we issued a license to the Raila Odinga presidential campaign to use the music for our members in all its forms and in all its style, as it were. The details of synchronization, mechanical works, those are complicated technical copyright legal issues that the client may not understand. And our advice is that if there was really any issue, then it should have been dealt with administratively and amicably, because we are not at war. Sauti Sol is our member. We represent them. We've done it with diligence. Obviously, this is a relationship, and as you relate, things will come, differences will come, even like in a family. But when those differences come, you don't jump to threatening legal suits. They should have come to our offices and seek guidance so that we can determine legally, and we get lawyers, by the way, because these are technical legal issues that require serious legal minds to determine whether the extent of the adaptation goes beyond the license we issued and goes beyond the doctrine of fair use. So jumping to court or threatening to go to court is not only embarrassing to our client, but also to us who issued the license. And it casts doubt about the validity of our work or the legitimacy. Now, it did not help matters that Kenya Copyright Board, who are used to running roughshods on CMOs, jumped into the fray to create more confusion by implicating or creating an impression that actually Sauti Sol are right. Now, we are not saying they're right or wrong. We are only saying we issued a license. And I'm giving an analogy of someone coming to a hotel asking for the cost of a cup of tea. Raila Odinga presidential campaign called us, and they asked for a license. And we are the ones who went and told them this license and ensures that you are able to use the music or the content belonging to our members, all the rights are subscribed to you or they are given to you to use for your political rallies and events. It's like coming to a hotel and saying this cup of tea costs 1,000, and then later on somebody tells you, oh, the tea bag was not costed. Those are technical details, and the client is not interested with that. The client asked for a cup of tea. They were served a cup of tea. They paid 1,000. Raila Odinga presidential campaign asked for a license. We issued them a license. They paid 562,000 for 1 year, an annual license to use until May 2023. Now, the technical details about mechanical rights, synchronization, adaptation, fair use, those are details that we can handle administratively. And the reason we are raising this conversation is to bring this matter to a close. We would like really, as decent Kenyans, to appeal to Sauti that we resolve this matter amicably. Let them come to our offices. It is not a matter between them and the client. If they want to take it that way, they have a right to go to court. But we don't want to be embarrassed in the process or embarrass our client by looking like our licenses were fraudulent. We are a company limited by guarantee. We are not a government agency. And we do not answer to the government except to the extent of complying with the law. We answer to our members. But it is our duty also to educate our members so that they don't embarrass our members before whom we represent and whom we license. This is a conversation to say there must be order and good manners. We cannot be rushing, embarrassing people, trying to create political nuances that are neither here nor there. We ask Sauti humbly and respectfully, please cooperate with us. We are your CMO. And we are telling Kekobo, keep off. You are not a CMO. You are a government agency. Your work should be to facilitate CMOs to function effectively and more efficiently. It's not to create controversies or create doubts about the operations of CMOs. And you will all remember that this is not the first time Kekobo is doing these kind of things. That they have been undermining our operations, and we think as a company licensed to operate in Kenya, Music Corporate Society of Kenya, Kenya Association of Music Producers, and the PRISC, we are not an illegality, and we do not need their unsolicited advice in the way we deal with our clients. The moment clients assign their rights to us, what we need is to operate within the law, which we believe we have done. Our response to this matter is actually ignited by Kekobo's response, which would have meant that we don't know what we are doing. If left unresponded to and unanswered, would have created an impression. Why then take a license if you are not sure where you will use it and how to use it? And if you use it, you can be taken to court. If you use it on top of your vehicle, somebody can threaten, well, we licensed you to use it inside. You know, if you use it in a tent, we don't want to be drawn into those details. We can sort out that matter amicably without splitting hairs. So this is where we are here, to say, Sauti, please, you are an honorable band, you are honorable members, you are people we respect, you have entertained us, you have brought joy to our homes. We love you, you are our members, we represent you. But when there is a controversy that can undermine the wider good of our operations, then we must also clarify that we don't need to embarrass clients who have been licensed, and we don't need to embarrass the CMOs and our staff who are spread across the country, who are working day and night to collect money on behalf of these musicians. We don't want anybody to ever imagine that what they are doing is not valid or is not legitimate. It is my duty as the CEO, and it's the duty of the board of directors to give credence and support and rally behind our staff and the operations and our officers to ensure that what they are doing is within the law. And as far as that issue is concerned, the issue of the license given by CAMP, PRISC, and MCSK, as far as that issue is concerned, and the adaptation of that copyrighted material, our position is, if there is any dispute, it is an administrative issue that we can resolve.